You can begin me. Thank you.
Good morning, good afternoon, good evening, wherever you are. Welcome to our webinar on the upcoming elections for the judges of the African Court on Human People's Rights. My name is Mayaman. I'm a legal officer at the Initiative for Strategic Litigation in Africa, and I will be your moderator today. Before we start the conversation, I would like to give you a brief overview and the purpose and objectives of this webinar. This year in 2024, there are 3 positions of judges to be filled at the African Court. And the AU and African Union policy organs will be electing these judges later this month, actually. Ahead of these elections, 3 academic institutions, namely the Center for Human Rights at the University of Pretoria, the Human Rights and Peace Center at Makerere University, and the School of Law at Kabarak University are collaborating with the Arusha Initiative in co-hosting this webinar. The Arusha Initiative, which my colleague Sophia will be speaking more about, is a CSO-led initiative that calls for a more transparent, participatory, and merits-based process in the nomination and election of African Union human rights bodies members. Now, going to the aims of this webinar. It aims first to provide more insight into the process of the nomination and selection of members of the African human rights bodies, which has been to a large extent really unclear and inaccessible as well to the broader public. The webinar also aims to generate more public discussion and raise awareness about these important appointments. But really, the ultimate game is to bring the AU institutions closer to the people of Africa, as well as to strengthen the legitimacy of the human rights bodies, including the court, which we will be discussing today. The discussion today will focus on getting experts' perspectives and reflections on the suitability of the candidates that are running for the 3 positions that I've previously mentioned at the African Court. So the discussions will revolve around the judges nominated for positions from East Africa, from Central Africa, and from West Africa. We have 3 panelists that will be speaking to us around these selections. But first, we have Ms. Sophie Ebe, who will be speaking to us about the Arusha Initiative, and will give us like a bit of a background on how the initiative started, and why it's important for civil society also to engage in these nominations. So Sophie, I give you the mic, and please, within 5 minutes, just explain to us and give us a brief introduction to the Arusha Initiative. Thank you.
Okay, thanks a lot, Mai. Hello, everyone. Good afternoon, good morning, depends on where you are. My name is Sophia Ebi. I am the coordinator of the African Court Coalition. We are based in Arusha, Tanzania. And thanks a lot. I think my moderator, at least she has given some few like a snapshot of the Arusha Initiative. So the Arusha Initiative is, it's a civil society-led movement. And when I say a civil society-led, I mean it is led by civil society, but it does not mean that we do not have other stakeholders. We do have different other stakeholders who are within the initiative. So it is the civil society-led movement which advocates for a more transparent, participatory, and merit-based process in the nomination and election of members of the organs of the African Union, and in particular, the African human rights mechanisms. The initiative was formally formed in October 2023, and its aim is promoting human rights by supporting state parties in the nomination and election of members of human rights mechanisms in Africa, and also aims to contribute to greater effectiveness, independence, and impact of such mechanisms. Additionally, the initiative also aims to bring the activities of the AU closer to African citizens and other rights holders on the continent. So why is the Arusha initiative very important? Of course, it is important because number one, we want to bring awareness to the African citizens. Many of you will agree with me that we do have the mechanisms. We have the AU, the organs, we have the human rights mechanisms. We do have engagement, but still there's a larger group of African citizens who are really not aware of these mechanisms and their mandate. So mainly it is to bring about the awareness and also the ownership, because when we are talking about members of this particular human rights mechanisms, and in particular, right now we are focusing on the three organs, which is the African Court on Human and People's Rights, the African Commission, but also the committee, the African Committee of Experts on the Welfare and Rights and Welfare of the Child. So when you actually, when the citizens are aware of the processes that are involved in electing these members, either if it's the commissioners or the judges of the African Court, it sort of like creates ownership, but also it increases citizens' participation and engagement with these African human rights mechanisms. And I'll give an example. For instance, with the African Court on Human and People's Rights, like us here, of course, we, the coalition, are part of the Arusha initiative, but we also have the mandate to advocate for an effective, independent and accessible African Court on Human and People's Rights. And one thing we have noted is sometimes even when we do advocacies, some citizens, African citizens, are not aware much of what the court does. But when it happens, when you have a sitting judge who sits from a certain country, then even the interests in that particular country of the citizens sort of like increase. The interest increases. They want to know more, to learn more about the African court. So I think this is quite important, and this is basically what we want to bring about, not only for the African courts, but also for the rest of the African human rights mechanisms. It will also help. I think most of you know that one of the biggest challenges that we have at the African court is the law ratification and the declaration that allow direct access. So the Arusha initiative in its essence, even though it is focusing on increasing transparency in the nomination and election of judges, but it can also enhance that part of citizens knowing more about the court and these other mechanisms, but also the need for them to participate. We've also realized that most of the time, like the calls will just come out and state will be required to submit the names of the nominees, but the larger citizens, like they are not even aware. And we have so many people who are experts or really good in the human rights field, but this, most of the time becomes like a missed opportunity for them, because they do not know about the process, how it's done. They do not know when the announcements are out. So the Arusha initiative is mainly aimed to enhance the citizens' participatory, but also to help the state as well to nominate the qualified people who at the end will go and sit either at the bench of the judges of the African court or these other African human rights mechanisms. I will end here. I think my 5 minutes are up. Thank you very much.
You ended within the 5 minutes, so well done. Thank you, Sophia, for this brief but rather comprehensive, introduction to the Arusha Initiative. Now we'll be speaking more broadly around the process of nomination and selection for candidates across the AU bodies. And the person who will take us through that is Prof. Frans Viljoen from the Center for Human Rights at the University of Pretoria.
Thank
Prof.
you
Frans,
very much.
please, within 5 minutes.
Thank you very much. Yes, I'll speak specifically because of the focus of this webinar about the judges. And let me start by the eligibility criteria. The eligibility criteria are found in the protocol, the court protocol, the rules of the court, and also in the note verbal, which is sent to states when they are asked to nominate candidates. The first eligibility criterion is the person must be a national of the African Union, of an African Union member state. So that's interesting. It doesn't have to be a national of a state party, a national of the African Union member state. I think we've seen in other systems like the Inter-American system, once at least, Thomas Bergenthal, who is a United States citizen, was elected to the Inter-American Court, nominated by another state. But I don't think that is going to happen frequently, and hasn't certainly happened yet in Africa, that one state would nominate a national from another state. The second criterion is that the judges serve in the individual capacity, and that relates to Articles 17 and 18 of the protocol, which underscore the issues of independence and impartiality. It says that a judge cannot hold a political, diplomatic, or administrative position. So it does mean that someone who holds those positions cannot be eligible for nomination. And also they cannot serve at the moment of nomination as a legal expert, kind of a person who is advising the government. So that is all about the kind of impartiality requirements that is reinforced by the rules of the court. The third criterion is that the person must be a jurist, so must hold a law degree. I think we can say it. In other words, it doesn't have to be a judge, doesn't have to be an academic, it doesn't have to be a practicing lawyer, can be any of those. And then must be of a high moral character. That's a bit open-ended. And then lastly, perhaps most importantly, the person must show that they are a recognized expert in the field of human and people's rights. And that can be based on practical, judicial, or academic expertise and experience. So often I think the nomination process for the African Court falls short at this hurdle, because we see that there is a sense in which judges are often nominated by default, not because they have particular experience in human and people's rights, but perhaps just because they are jurists. So I think if we look at the criteria, the pertinent one, the one that I think from an academic point of view one wants to push for more articulated concern being weighted on it, would be this last criteria of recognized practical, judicial, or academic experience or competence in the field of human and people's rights. Again, it does not require judicial experience. It does not require practical experience or academic experience. It's an either or. It can be either in an academic field, in a judicial field, or in a practical field. Now, there are two processes that now will bring us to a judge being selected. The first, obviously, at the national level. At the national level, there is a process of nomination. That's where the process starts. Who nominates? The state. The state nominates. There is a note verbal sent to the states 3 months in advance, and then they nominate. They can actually nominate 3 persons, of which 2 should be nationals and 1 need not be a national. Now, the African Union, in a sense, has, because of other imperatives of regional representation and gender representation, they've made a very rigid system. They have divided Africa into 5 regions, as we all know, and in each of those regions, 2 judges are to be selected, and there must be 1 male and 1 female. Therefore, the vacancies this year are East African male, West African male, West African female, and Central African male. And that obviously rotates over time. The 11th judge is rotational, is not attached to a particular region, but that rotates across the 5 regions as well. Now, the problem with the nomination at the national level has been that it is an opaque, a very closed process. So what we also tried to achieve with this process of creating more light shining onto these issues is to ensure greater transparency and greater participation of civil society, national human rights institutions, and academia, the press, in the process of identifying a candidate at the national level. The note verbal that is sent by the African Union actually emphasizes this element and requires states to make this process more transparent. Unfortunately, up to now, the processes have been quite opaque, quite closed, and driven perhaps by the executive, by one ministry. So again, I think the effort that we are engaged with here is also to work towards states making that process much more open and participatory in order to get perhaps a greater merits-based nominations that are put forward. The next layer, once we have the nominees, these nominees list is shared, and then interestingly enough, it is not the 34 state parties. The 34 state parties alone can nominate judges for election, but it is the AU as a whole, all of the 55 states, that actually select the judges to be appointed. So one would debate that, and we can talk about that if people are interested. It's a secret ballot, and obviously the idea is maybe that the court doesn't have a separate conference of state parties. The court is within the fold of the African Union, and hence it is the AU and not the state parties who elect the judges. In anticipation of this particular year's process, we, as the initiative and the Center for Human Rights, from an academic point of view, wanted to look at the candidates that are availing themselves. And we looked at, in particular, the 2 judges in Central Africa and in West Africa that are eligible for re-election and made themselves available again for re-election. We asked ourselves, how can we assess the performance of these judges sitting on the African court? It is difficult if they sit en banc as a collective of 11 and they give judgments, speaking as one of 11 judges. Fortunately, in respect of Judge Chikaya, he has given quite a number of dissenting and separate opinions. And we analyzed those opinions to try to figure out what kind of jurisprudential approach Judge Chikaya represents. We were slightly concerned that in admissibility cases, a particular Kambole case, Judge Chikaya took a much more restrictive approach than the majority in terms of the period that would be allowed for the submission of a case to the court. But the main area in which Judge Chikaya dissented was on the death penalty. While the majority of the court, looking at cases involving the mandatory imposition of the death penalty in Tanzania, found the mandatory death sentence to be violating the African Charter, Judge Chikaya insisted on making a much more broad pronouncement that all forms of the imposition of the death penalty would violate the African Charter. We found that his reliance there was very much on international trends, on, for example, protocols adopted in the Council of Europe and on trends within the international community. We also found in a general way that Judge Chikaya put much weight onto authorities that come from especially the European Court. The second big area in which he dissented was in the elaboration around the margin of appreciation. While the majority did not want to embrace a fully fledged margin of appreciation, giving leeway to states to interpret especially the balancing of rights, Judge Chikaya pronounced that the margin of appreciation should be applied by the court. But our concern in our analysis was that he made that conclusion, he arrived at that conclusion seemingly on the basis of the margin of appreciation having been established and made very operational within the European system. There was an unquestioning kind of transition or transposing of the arguments from the European Court onto the African context without contextualizing those. So those gave us some cause for concern in terms of Judge Chikaya's jurisprudential route. And also some of his minority opinions were sometimes not fully substantiated and fully reasoned. As far as Judge Anukam is concerned, and I'll conclude here, moderator, she gave very, very few dissenting opinions. We counted 2 dissenting opinions, 1 dissenting opinion where she said that she dissented, but she did not write, she did not articulate her reasons, did not make a declaration, and 1 separate opinion. We found it difficult to look too deeply into her jurisprudential approach. The issues on which she dissented were relatively technical issues. They did not concern issues of a fundamental nature respecting human and people's rights. And we wondered, to the extent that she had already in these 6 years in her term started to find an own voice, own form of engagement with the African human rights system. So, we obviously do not see our little analysis as anything prescriptive, but we do think it is a salutary route to take, namely to also, during the terms of our judges, to pay more attention to the jurisprudential contributions and the jurisprudential approaches that emerge from especially the minority opinions and the separate opinions. So I hope this small background will also give us some guidance in our discussion going forward. Thank you, moderator, for the opportunity.
Thank you so much, Prof. This has really been helpful, especially, the analysis and the outcomes from the study that was conducted by the clinic at the Center for Human Rights on Justice Chikaya and Justice Ankam. So now going deeper into the conversation, the next portion of the conversation will be around assessing the candidates that are running for these positions from the different regional blocks. We will start with the East Africa bloc, and we have Dr. Bosingi Kambuba from the University of Makerere in Uganda, who will give us a Ugandan perspective really on background around the suitability of the Ugandan candidate, who is Justice Duncan Gasagwa. So I give the mic to you, Dr. Bosingi. Thank you.
Hello, Mai. Sorry, the network had been a bit interesting. Thank you very much for having us for this. It's a pleasure to collaborate with the Center for Human Rights and Kabarak University on this and the Arusha initiative on this quite important, I think, discussion. In terms of Justice Duncan Gaswaga, he's a very interesting candidate. In terms of his background, he began as a magistrate in Uganda before going on to a secondment to the Supreme Court of the Seychelles in 2002, and he served there until 2013, so about 11 years there. On his return, he was appointed a High Court judge, and he has been a High Court judge in Uganda since 2014 rather. In the High Court of Uganda, he has served in various capacities in terms of, especially in the International Crimes Division, and is currently resident judge in a place called Lira, a part of Uganda. His service in Seychelles was, well, in terms of the nature of that country, a lot of it went into questions around maritime law. So that is something that has also reflected in his writing, and he also got interested into questions of international law broadly and terrorism, and that also may have informed his service on his return to Uganda in the International Crimes Division of the High Court. And that is reflected also in in some of the academic writing he has done. For instance, there are about 2 articles from 2013, one talking about the definition of terrorism, and the other was looking at whether the International Criminal Court has jurisdiction over the recruitment and use of child pirates. So his service in Seychelles seems to have drawn him closer to questions around international law, terrorism, and piracy, and questions of that nature. Now, in terms of his education, he has a bachelor's degree from Makerere University, a diploma in legal practice, and a Master of Laws from Case Western Reserve University, and also a Master of Laws from the University of Pretoria. So he's a fellow Pretoria alum. Interestingly, his dissertation, which was written in June 2013, completed under the supervision of Professor Michelo Hasungule, considered the right to self-representation and its challenges to the administration of fair trial at the ICTY, lessons for the ICC. So I think it's evident from his published work that he has concerns around international law broadly, questions around maritime law, and questions also about the functioning of courts. He brings, I think, to the court, he brings to his adjudication a very, I think, instrumentalist approach to law that is not necessarily hostile to human rights, but rather considers human rights insofar as they relate to the administration of justice broadly. So he seems to be, I would say, instrumentalist or functionalist in that sense, concerned about efficiency, yes, concerned about justice, but also concerned about the extent to which the process of court might be affected by trends, certain trends such as the right to self-representation. So I think that thesis actually is interesting insofar as it represents his thoughts around how to balance certain human rights with other human rights, including concerns around fair trial guarantees. Now, that leads me to another issue, and this, I think, perhaps related to part of the points that Prof. Filun made, that in a lot of his decisions, maybe it's a function of the nature of the courts to which he has been posted in Uganda, or even in Seychelles at the time, that a lot of his decisions have been in the area of criminal law and international criminal law, so not too much human rights. So you won't find a decision that, well, at least I've not been able to find a decision that of his that necessarily foregrounds human rights as such. But at the same time, I've not been able to find a decision that necessarily constitutes a negation of human rights principles, human rights concerns. There have been cases, some famous ones in Uganda, such as the Ugandans attending will be aware of the case of Nsenga, for instance, a prominent case of the woman who was accused of killing her husband. But in a lot of those criminal cases and some of, in terms of his sentencing practices, there have been questions, there have been cases where he reflects on the human being as such. In one case, for instance, in sentencing, he reflected on the fact that it's a human being who was killed, the life of a human being at stake. So while not using the language of human rights as such, you can see a concern for human dignity or the sanctity of human life. So which might be a positive sign in terms of what we'll be able to do on the African court if actually successfully elected. I would also say that so really, and this may be a context of the political economy of Uganda, it's quite difficult to get nominated to the African court from Uganda if you have been very upfront about questions around rule of law, good governance, and things of that nature. And so to that extent, it could be that his nomination reflects It could be, well, it can be a reflection of the fact that the state is comfortable with the nomination, which might be a problematic sign. But at the same time, a reading of his decisions and his written work does not, at least in terms of what I've been able to find, does not present anything of concern to the human rights community. And so to that extent, at least on the basis of the public record, there's really nothing that would be of concern to practitioners, activists around, if indeed you're elected. So I think he might have learned from the experiences of other jurists who were who issued decisions that then marked the end of their judicial careers. And so it could be that he has been careful in terms of judicial economy, and has straddled the line between doing justice and not at the same time getting caught in the crosshairs of the state. So which really leads to I think from my sense, the idea that if one was not aware of the political context of Uganda, one might say that his record is difficult to read. However, based on the judicial decisions of his that are in fact present, based on his written work, based on his experience and career to date, I think he would meet the test, the third test Prof. Filun set, in terms of competence in human rights, and I can think of much more troubling candidates that might have been nominated from Uganda, and he's not one of them. And in terms of so really, I think on any scale from 1 to 10, he leans more towards the 10 being human rights positive, and 1 being the opposite. I think Justice Duncan Gaswaga leans more to the 10 in terms of being a positive candidate for human rights concerns. I'm conscious about the time, and out of respect for the panel and the participants, I'll leave it at that mind. Thank you.
Thank you so much. Really appreciate it. And I think you've given us a very, enlightening background on the candidate, and the analysis that you have put forward also is very, very informative. Maybe just one question to you, Dr. Bosinge. The process-wise, was it made public that that the process is starting? We need to put forward the candidate from Uganda?
No, and that's consistent with a lot of the processes, even nationally here. It's not it's rather opaque, and so there's not been any public involvement as such.
All right. Okay. Thank you so much. All right. So now we will move forward to discuss the second candidate from East Africa. And the person who will be leading the discussion is Dr. Jafet Bigon, who works with Amnesty International but has a long working relationship with Kabarak University. Yeah, and he will give us, a Kenyan perspective basically on the upcoming candidate. Dr. Jafet, the mic is yours.
Thank you, Mai. Can you hear me?
Perfectly, yes.
Yes. Thank you. I'm glad to be here this afternoon to make this quick presentation. The candidate from Kenya who has been nominated is Samuel Mbidi Kimeu. But before I go into the details of his candidacy, let me just preface my presentation with 3 particular things. First is that Kenya has a very long history of nominating individuals to international and regional human rights bodies. As you may know, one of the retiring judges from the African Court now is Ben Kioko, and before him, we had Githu Muigai, former Attorney General, who served briefly at the African Court before he resigned. We have had an individual at the African Commission, Lawrence Mute, We've had individuals at the Children's Committee. Martha Koome, the current Chief Justice, once served at the committee, and also Justice Joyce Alwoch also served at the committee and then went forward to join the ICC. So Kenya has had that history of nominating, not just here, but even at the UN system. Secondly, is that despite this long history of nominating individuals to regional and international bodies, there is no transparency and openness. The positions are not advertised, the positions are not made public, and therefore the nomination process is shrouded in secrecy and opaqueness. And this is quite contradictory, because for positions at the national level, there is actually quite a robust open process that even in certain instances includes live TV interviews or live streamed to the public for certain constitutional positions. So there is a disjuncture between what happens for relevant positions at the national level and for these positions for regional international bodies. Now, on the current candidate, Samuel Mbidi, first, I must begin by saying that he's a long civil society practitioner. Is a lawyer and who has worked as an executive director of the Kenya section of ICJ, International Commission of Jurists, but also very well known in the country and perhaps even continent-wide in his work and on corruption matters. He served as executive director of Transparency International for a long time, and his name has come to be synonymous with anti-corruption efforts in the country. And in addition to that, he's also served as a member of the African Union Advisory Board Against Corruption. So he's not necessarily new to African Union bodies, having served in one of its treaty bodies. In terms of academic qualifications, in addition to a law degree, he's also done a master's degree from Notre Dame Law School. And here, his dissertation was on a human rights topic, human rights in multi-party Kenya, critical appraisal of the judicial role, done in 2007 as part of the master's program. And he's been admitted to practice law in Kenya in 2005. So that means he's been formally admitted to practice law for 19 years. And under Kenyan law, as you know, one of the requirements is that you must be someone who is qualified to be appointed to the highest judicial office. So at the face of it, he satisfies that requirement because he's been admitted to practice law for 19 years. But of course, one has to go deeper to check whether he's been renewing his practicing certificate, which in any event is not necessarily important if you consider the definition of a jurist much more broadly. And then in terms of now his human rights experience, he has published written beginning from his master's dissertation. He has published a conference paper, a book chapter, and a journal article, two of which are on corruption and land issues. And then the other one is on Kadhi's Court in Kenya and on forceful evictions with a nexus between corruption, land, and human rights. So when you look at his writings and his career, it has been predominantly on corruption issues and not necessarily in mainstream human rights issues. So from this research, his publications, from his career in Transparency International, in anti-corruption efforts, it is a little bit difficult to analyze and gauge the depth of his knowledge in human rights issues and human rights jurisprudence more broadly beyond the small area of forced evictions and its connection to corruption, or corruption and its nexus to human rights. But more broadly, in terms of strictly speaking, in terms of the criteria, if you just look at them on the surface of it, on the formality of it, then he satisfies them. But perhaps a deeper analysis may question a little bit his depth of human rights and jurisprudence that might be required to serve as an effective judge of the African court. I think I'll stop there, unless you have a specific question to add on to that.
No, thank you so much, Dr. Japheth. And maybe here I'll just also like to mention that we have reserved 20 minutes for questions and discussions after the presentations. But in the meantime, of course, everyone who's online, you are more than welcome to choose the chat, to use the chat box for any, additional information or question that you want to ask. Moving to Central Africa, we have Dr. Tresor Makonia, who is an associate professor from the University of Goma, and he will give us a bit of a reflection from the Central African perspective on the Justice Chikaya, who is re-elected to sit at the African Court, but also maybe why there hasn't been any other nominations from the region. Tresor?
Thank you. Thank you, Mai, for the opportunity. I think I was asked briefly to talk about the issue of nomination in Central Africa and why specifically there was no candidates, given that I was involved in a personal capacity in the process of finding a Congolese suitable candidate. So I think I have some ideas to provide from purely a Congolese perspective. So I will have, I'll talk about 4 main points. The first one is the fact that in the DRC in particular, there is no formal process or formal procedure to nominate individual to deal with candidates to human rights bodies, whether at the African level, but also at the UN level. So whenever there is an opportunity to submit application, I think most of these are dealt with on a case-by-case basis. And usually, the country is a little bit big, and most of the time, these are professors based at the University of Kinshasa, and there is little involvement of those based in other regions of the country, but also of the civil society organization. So when you see a debate, you will just hear that there was a candidate from the DRC, and no one participated in the process. And this actually reflects the general culture of lack of transparency, inclusivity, and participation in the nomination of top officials, including judges. And when one looks at the same issue at the constitutional courts, there is no debate around suitable candidates. And I think this also goes to the other level. So the second point that I want to talk about briefly is the lack of coordination among key state entities in the nomination process. So 3 entities, in my view, are relevant in this process. The first one is the head of state, the office of the President of the Republic, which formally submit the application after the person has been approved. The second entity involved here is the Ministry of Foreign Affairs and the Ministry of Justice. And sometimes candidates, depending on which individual they are close to, will be supported by the Ministry of Justice or the Ministry of Foreign Affairs, or some advisors, top advisors of the President of the Republic. And then you will see at the end of the day, you have 3 candidates who never spoke to each other and who are supported by different individuals and different entities. And there are backlashes and no discussion, no collaboration. And at the end of the day, sometimes you see the Minister of Foreign Affairs who actually support the individual. And the lack of coordination is also illustrated by the fact that candidates, whether suitable or not, can be supported by the office of the head of state, so President of the Republic, but when the name is sent to the Ministry of Foreign Affairs and the Minister of Foreign Affairs refuses to appoint the individual. I remember there was these debates when there was a candidate who was supposed to be appointed, or the candidacy was supposed to be submitted and supported for the International Law Commission, the UN International Law Commission. But when it went to the Ministry of Foreign Affairs, there was debate of whether the individual was member of the ruling party. So you may be well qualified, but if you don't have the support of the ruling party, or you don't have individuals inside the system who support you, that will be a little bit problematic. So the third point here, I think, is about the role of the new International Law Task Force. Since last year, I think the Minister of Justice created an International Law Task Force that mainly deals with issues around international law, international criminal law, and international human rights law in the country, especially litigation. So, as you know, the DRC has pending cases before the African Court on Human and People's Rights and the East African Court of Justice. It's this task force that deals with the litigation, selects counsels and other tasks. So, the International Law Task Force has taken into hand the matter of appointment. So, when it was clear that there was a seat available for Central Africa, the International Law Task Force put together a team, including myself, tasked with this, understanding the process and selecting individuals who will be supported by the Democratic Republic of Congo. So what the task force did was to receive applications. And I think we had 10 applications. Most of them were professors, but also other NGO or people who have worked for NGOs for more than 20 years. So out of the 10 applications, we had to reject 6 applications because on various objective criteria, for example, the familiarity with key human rights issues, familiarity with the African human rights system. So the preference was given mainly to individuals who were familiar with the African human rights system than the others. And what was interesting actually within the task force, among the 10 candidates, and then later among the 4 candidates, there were serious debates and what are the jurisprudential positions of each and everyone on key human rights issues on the continent. And the CV one has to look at what did you write on, what is your take about Africanization of international law, Africanization of international human rights law. Are you more Eurocentric as an academic, or you also take into account African perspectives, as France earlier looked at when examining the application, while examining the jurisprudence of Judge Chikaya. So what is interesting, Judge Chikaya comes from the Republic of Congo, and the Democratic Republic of Congo. So most of our academics, most of them were trained in Belgium and France, and as such, most of them are more familiar with the European human rights system than the African human rights system. So that's why it was easier to reject a number of applications, and we had a little number of individuals who understand the system. But then the main issue that we faced was how you manage the different ambitions, because there are certain individuals who did not want to associate themselves with the task force, because, you know, the task force was established by the Ministry of Justice, and you are not obliged to go through the task force to be nominated. So that some people went directly to the office of the President of the Republic. So we had, you know, different levels, and others refused to come. And then we finally selected one individual to submit application, but there is also one who wanted to go alone, and there was no coordination, no discussion about that. And at the end of the day, when the deadline ended or expired, we realized that there was no application that was submitted on behalf of the Democratic Republic of Congo. And up to date, no one knows why there was no application, why we we submitted one to the court. So in terms of conclusion, I think my take on all this process is that the good thing, despite the fact that the DRC ended up not proposing or sending any application, I think the good thing this year is compared to previous years. I think this year there was at least a debate within the community. Here, I think the task force and among other professors will reach to each other and try to select the best. So there was at least the debate at that level, because previously you just hear that someone was appointed, someone was elected, and you didn't know what happened. But something to work on for future application, I think it's two things. The first one will be the issue of inclusivity and participation. So we have to see how inclusive the process will be, the process of appointing judges. And the other issue will be the issue of transparency, because it doesn't mean because you are supported by the President of the Republic or the Minister of Foreign Affairs that you are suitable candidates. So transparency in matters of trying to understand how suitable your application is and how better you will support the human rights system in general. I think these are some of the issues we will need to talk more about for upcoming nominations. So, well, I think I will end there unless there is a specific question. Thank you so much.
Thank you so much, Fraser. And I think it was very interesting really listening to you, like giving us an insider, perspective on the process. But maybe one question would be, was there any clear role played by civil society organizations, or even as part of maybe the task force that was developed?
No, there was no role. So I think as part of the Arusha initiative, there were links sent to different civil society organizations. I think the role was merely to propose a number of some names, but there was no activity, no campaign, no conference on this. And that's, in my view, problematic. And these are some of the issues to work on for future similar process.
All right. No, thank you so much. Thank you. Okay. So we are left with one candidate, Justice Mario Dali, Senegalese candidate from West Africa. However, we don't have a specific speaker to address the nomination from West Africa. And we'll open the floor to anyone from our audience, really, who has any perspective, any insights they would like to share. You can write in the chat box, you can raise your hand, and we will allow you to speak. The same offer is extended to our panelists as well, if you have any input really on the West African candidate.
Sorry, Mai. There's already a question there that has been posted on the chat. Maybe you can read that.
Okay. So we have a question from Lydia around how do one appreciate or determine the inputs of individual judges in their collective judgment. I think maybe Prof. Franz, we can hear your thoughts.
Yes. Thank you very much. Yes, and thank you for the question. I think, yeah, maybe we move, moderated now, into a general part of discussion and questions and answers. And I suppose what you point out in your question, Lydia, is very central to what we had to address when we tried to make sense of looking at how to assess the performance of a judge of the African Court. Now, when the analysis was made of Judge Gaswaga, and a sitting judge in Uganda, his suitability or eligibility for the court, I think that is obviously much easier because that judge sits at the national level. He or she hears cases. They may sometimes sit as 3 judges, but most often they can sit as a single judge. They can give their own separate opinions and their own dissenting opinions as well. So I just want to make this clear distinction. To look at the suitability of a judge at the national level for appointment to the court, I think is quite a doable endeavor, because by the very nature, those judges would usually have quite a reach of individual opinions or individual judgments that we can assess. And I think Dr. Businje had done exactly that. He looked at some of the judgments and said that it's difficult in a way to look at his human rights kind of jurisprudence because he had steered into areas maybe ancillary to human rights, but not quite in-depth human rights. Now, coming to the African court, certainly it's much more difficult because if you have a court of 11 judges that, generally speaking, give a judgment en banc, to use the French, right, as a collectivity, as a collective. If, for example, we had no dissenting opinions or separate opinions from any of these other judges, how do we assess their performance? Should we assume that they have associated themselves completely with the majority? So in a way, if you then look at the majority opinions of the court, you can also transpose those judgments to the individual judges, and you can analyze those judgments as if the individual judges have been fully responsible for or involved in the drafting. However, our experience, in working with the court shows us that it is often very different. There is a big role of the secretariat, the registry, in the formulation maybe of an initial judgment. And then, there may be a judge that is specifically designated as a rapporteur that does maybe a lot of work on a particular judgment. And some judges may, in essence, just disappear and give very little input, into that process, if they are not perhaps the rapporteur judge. So is it fair now to take every judgment, and let's say Judge Anokam, which has given a limited number of separate or dissenting opinions, do you assess her voice by looking at the majority's voice, and do you ascribe everything that the majority has done or had stood for also to her? To some extent, you can, but to another also, it does make the analysis a bit awkward, because then all 11 judges will get the same assessment, isn't it? They will all be assessed by virtue of having been part of the 11 judges. So that negates the purpose of perhaps shining a spotlight on the individual judge. For that reason, I think one is really kind of constrained to look at the dissenting opinions, the separate opinions. And then you also maybe fall in a trap that you say the mere fact that the judge gives dissenting or minority opinions, is that a virtue in itself? They've given their own voice, but perhaps, in a court that is very collective, you would expect those with minority views also to raise those views in the court, try to convince the other members of the court. And maybe a judge that doesn't write often minority opinions or separate opinions have actually been successful in convincing the majority of their views, and you should perhaps not hold it against them. So you can see, we concede that it is a complex matter. You can, I think, not really take the judgments of the court as a whole and analyze an individual judge's performance. And the best tool we thought there is to look at the separate opinions and the dissenting opinions. I hope that answered the question.
Thank you so much, Prof. Franz. Lydia, if you have any follow-up, if all is clear, yeah, you can, or you have any follow-up question, you can write in the chat box. But now I'll move to Ikechukwu Azuma, who will be speaking to us about the Senegalese candidate. Ike, please, we can take the floor.
Thank you so much, May. And let me just preface this by saying that I do not know this candidate, but in our work as part of the Arusha initiative, we did Dex research just on to collate available information online on this candidate. And we hope that we have someone from Senegal that may know more about this candidate But in the absence of that, we'll just reel out what we have found online about this candidate and encourage everyone to follow the Arusha Initiative on Twitter and join the initiative so that we would keep sharing more information on this candidate. Now, the candidate from Senegal, who is the second candidate from the Western African region, is Marie Odile Tiakane Ndaye. And like I said, is Senegalese. We didn't find a lot of information or any information actually on educational background, but on her professional background, Justice Ndaye is currently president of the Chamber, Dakar Court of Appeal. She was appointed in 2021, and previously she was president of Tribunal du Travail Hors Classe de Dakar. That's the Dakar Upper Pay Range Labor Court, and was also president of the Dakar Labor Court, appointed in 2015. And before that, she was a judge of the Dakar Labor Court before 2015. In terms of her compliance with the criteria, we just try to use available information as well to assess compliance with the criteria. And in terms of being recognized, practical, judicial, and academic competence, Judge Ndiaye, like I said, is practicing judge, currently president also of the Association de Femmes Magistrates du Senegal, that's the Association of Women Magistrates in Senegal, and she served on the working group that produced the Universal Charter of the Judge. And then experience in the field of human and people's rights, most of her experience, jurisprudence of her work in the last few years has focused on labor law in Senegal. She's been an active voice for women's participation in the legal profession. In terms of experience in more than one principal legal tradition in Africa, Justice Ndaye has experience in Senegal's legal civil law system, but it's unknown whether she has experience in any other legal tradition of Africa. In terms of her linguistic capacity, she's worked in French for the most part, and competence in other languages is unknown. In terms of meeting minimum requirements for highest judicial office in the country, in Senegal, Supreme Court judges are appointed by the president upon recommendation by the Superior Council of Magistrature, Constitutional Council, equivalent to the Supreme Court of the highest court of Senegal. And members are appointed, like I said, by the president, and that appointment is ratified by the National Assembly. And so it does appear like Justice Ndiaye meets the minimum requirements for the highest judicial office, since she sits as the president of the Chamber of the Dakar Court of Appeal. But again, my analysis is not dispositive. In terms of independence, there are no apparent linkages with the government or any other activity that could, on the surface, show any impairment in her independence. And and in terms of checking on adverse media, there was no apparent adverse media report on her. So this is just a brief about Justice Marie Odile Tiakane Ndaye from Senegal. She would face off with Justice Anokan, who is the incumbent judge for this single seat for West Africa. Thank you, May.
Thank you so much, Ike. This is really helpful. I mean, and like you said, I think through the Arusha initiative, we'll continue to engage further with these elected justices. From the chat box, we have a question posted by Valerie. Is it possible to separate political influence and suitability of the nominated judges, considering the fact that the nomination in most countries is a preserve of the executive arm of the government? I think it would be really helpful to hear from the panelists, really. So maybe we can start with Japhet. Any reflections around this question?
Thank you, May. At the domestic level, I think it is possible to ensure that there is merit-based, open and transparent processes. In a study done a few years ago by our colleague and friend Tarisai Mutai on behalf of the Open Society Justice Initiative, he identified a few countries in Africa, including South Africa, where there is interviews even for positions to international and regional levels. If that process is embedded in the law, like I said before, for instance, in Kenya, there is a public participation process in appointment processes in national positions. So if at the domestic level, such a kind of a process is instituted, then there might be some level of merit-based, open and transparent process. Where there is much more difficulty in ensuring that process is then at the election, at the regional level, at the African Union level. As Professor Franz did say, at that level, the Executive Council elects the individuals who have been nominated. At that level, there is much more politics involved, and particularly horse trading, where states vote in favor of each other in return for voting on other issues. So that's where there's a major problem. So although it's still the case in many African countries that the process is really political, the executive holds the cards close to itself, it doesn't make it open, and therefore there is some level of patronage. But if there is a push, and this is a long-term goal of the Arusha Initiative, that in the long term, we institute domestic processes where nomination is merit-based, open, and transparent. Then at that level, we can start seeing a change. And then we move into the regional level. Yeah, so that will be my reflections on that question.
All right, thank you so much. Trezor, do you have any reflections, additions to make to this question?
No, I think there is no specific element. I think I always believe that for such of this process to be devoid with political influences, to ensure that there is openness and public participation in the selection of candidates. But one aspect perhaps is to look at the power of the executive. You may be selected after interviews, but when the executive has still the power to decide whether or not you will be appointed or you'll be finally selected, because sometimes, although there were interviews, the discretionary power of the executive is such that they may either ask, again, the Judicial Service Commission, where these institutions exist, to start reorganizing interviews because they believe that the process did not yield to satisfactory results. So I think we should, in this vein, try to see how do we make sure that there is more participation. And on top of that, how do we constrain the discretionary power of the executive to make sure that they appoint the person actually who was selected after the interview? Yeah.
No, thank you so much. Dr. Busenge, do you have any addition to this question, reflections from the Ugandan perspective or East African perspective?
Thank you, Mari. I'll just perhaps speak to the Ugandan context. And I mean, just to agree really with what Trezor and Javed have said, that it's really especially in closed, to use for lack of a better term, closed context such as Uganda, where you have an incumbent president who has been in power now for close to 40 years, and where the process is not as open or participatory, is neither participatory nor really democratic. So the process is similarly opaque for regional courts such as this one. And so to that extent, it becomes, it's really difficult, if not impossible, to remove the political aspect from the nomination. And this also informed my part of the comment I made earlier that as to why perhaps the I need to be a bit careful here. Receive of really terrible candidates as nominees, because then you have judges competing to get to catch the eye of the executive, to please the executive, with decisions in terms of human rights. And so, to the extent that Justice Gastwaga doesn't have, at least I've not been able to identify any judgments of that nature, I think that's a plus for him. Because really judges in Uganda are operating in a very difficult context, and those judges who want to do the right thing have to find a way of doing the right thing in a very in a very diplomatic manner that does justice without necessarily attracting them.
Thank you so much, Dr. Besingwe. Thank you so much. We have 3 more questions in the chat box. The first one is, will the shortlisted nominees be interviewed for the position? Prof. France, do interviews take place?
Regrettably, at the AU level, no. The AU, I think works basically on the CVs, and then the processes of horse trading. We even sometimes find that at the last minute, there may be, let's say, 2 East African candidates like we have now, 2 men, but there could be for, like a horse trading. In other words, Kenya can agree with Uganda that next time around, when we want a position on a UN treaty body, you will support us. We will retract our nominee here. That is the worst kind of situation that we sometimes see happening, that the choices that are there may be made impossible because of political issues. But no, that is what I think we try to do at the Arusha Initiative as well. I think the first step is now to, in a sense, collect the CVs, have this kind of discussion that we have exactly today. But eventually, I think one would try to have the candidates' CVs being discussed much more in the public domain. For example, potentially be for the Pan-African Parliament, as an example, and to, as they do in the Inter-American system, have a panel of experts look at the CVs and write a report, and that report is then disseminated and made part of these proceedings. So yes, ideally we should have interviews, but in the absence of interviews, I think there is much that we can contribute, and I think today is the start of that process. Thank you.
Thank you so much, Prof. Another question from Olotosin, and she's asking, she's curious about the influence of federal character on such nominations, like the case of Nigeria, which follows a federal system. I'm not sure who from our panelists can contribute to this question.
I can try.
Yes, please go ahead, Dike.
Yeah, I think just like other panelists have shared, the process in Nigeria doesn't appear to be radically different. For the most part, it's mostly informal, and I am aware that at sometimes the NBA is consulted, that's the Nigerian Bar Association, and other times even the National Judicial Council is consulted, but ultimately the decision lies somewhere between the Ministry of Justice and the Ministry of Foreign Affairs. Most times, the Ministry of Justice is more authoritative in terms of making the recommendations to the presidency, and that's why you find that most times, at least a little above 50% of the times when you have these appointments, they are directors of the Ministry of Justice, but are not necessarily jurists or judges who are serving at the time. There have been times when judges have been appointed, but at least the sitting judge we have now at the African Court was a director at the Federal Ministry of Justice. And so I don't think that there is any reflection on federal character in terms of because you may not find a lot of these positions. Because I think again the perception is not that the judicial positions as such, that's talking about the ICC or the African Court or other judicial or quasi-judicial bodies, are considered as different from other openings, let's say at the World Trade Organization or the other international organizations where Nigeria has to make nominations. So they are all, in a sense, seen as just nominations by the country. And so they may not be specific attention given to federal character that is unique to judicial or quasi-judicial openings for the country. And so I'm not sure if federal character is considered holistically when these appointments to regional or international bodies are discussed. But with the specific reference to the courts, I'm not certain that federal character is considered.
Thank you so much, Ike. And we are running out of time. So the last question is, and maybe Ike, you can take it up as well, is around the extent to which human rights institutions and civil society organizations in West Africa are involved in the nomination process of candidates to the African Court.
Yeah, so the situation in Nigeria would reflect what happens across board. And I spoke to some colleagues who were involved or who were aware of what the process was for the recent nomination in Senegal. And it wasn't participatory, it wasn't consultative, especially with civil society or human rights organizations, or even with the bar associations and the like. So it still remains mainly opaque, the process. It's not as transparent, and it's not participatory at all, which is why it's important for civil society to organize and assert the role that they should play in this process. Because for the most part, on the one hand, it doesn't appear that these nomination processes are taken as seriously, and secondly, it doesn't appear like there's an understanding that this is a process that requires broad engagement or broad consultation. It's seen as just an exclusive reserve of the executive, and sometimes it's not given the seriousness that it deserves. And so my understanding at the moment, I don't have empirical data to support this, but my understanding at the moment and what we've learned from processes is that there's no clear process, it's not transparent, and it's mostly on ad hoc basis. And so a lot more has to be done in terms of organizing civil society and human rights institutions, but even more importantly, ensuring awareness in the general public of why these institutions are important and why they should be engaged in determining who their countries nominate to these positions. And I think that's where the Arusha Initiative comes in to help provide that platform.
Thank you so much, Ike. Thank you. We will take the last contribution from Bright Deborah Queen. Your hand is up, so please you can unmute and speak. Deborah, you're muted. Please unmute and then speak.
Okay, can you hear me?
Yes, we can.
Okay. I although I came in a bit late. So my question is all about how can we protect human rights in Africa, like the country where I'm from Nigeria, and we are holding governments accountable for this, and we need to create awareness to this. But how can we protect human rights in Africa as a whole? I think that's the question I want to ask.
So your question is, how can we protect human rights in Africa?
Yes.
Okay, thank you so much. Maybe Trezor, would you go for this question, please? I don't think we have Trezor with us.
Yeah, since Trezor is not here, I can also take a stab at this since we
Okay.
don't have a lot of time.
And then maybe EK, because we're really running out of time. There is another question from Charlotte who's asking about when Prof mentioned that when citizens are aware of the process of nomination, it increases their ownership of the decisions made and increases their participation. When and how are citizens provided this information? Which citizens? Basically, how can we make sure that the African citizens are involved in this process? Maybe you can also, answer this question briefly before we go to the conclusion section. Thanks.
No, sure. Thanks, May, and thanks, colleagues, for this very interactive webinar. I think on the first question on how we protect human rights, I think that's a huge question, and what we are doing here today sitting at this webinar is an attempt to further the protection for human rights, because the regional human rights mechanisms play a critical role in protection of human rights. They have the mandates, from the court, from the protocol establishing the court that draws life from the African Charter, the same you could say for the African Commission and for the Committee on the Rights and Welfare of the Child. And so you find that there are many ways for protecting human rights domestically, regionally, continentally, and the like. And in the context of this conversation, enhancing the capacity of the African court by ensuring that the best experts are nominated and selected on the bench is a critical approach to protecting human rights. Because ultimately, you want the court to be a human rights court and not just a court of technicalities and a court where there seems to be a push to find deficiencies in procedures to drop cases or to decline admissibility for cases or the like. You want a court that focuses, that is victim centered, that is human rights driven, that seeks to advance the understanding of human rights and the provisions of the African Charter with respect to the African court. So one key way of protecting human rights is enhancing the efficiency and the impact of these human rights mechanisms. There are, of course, a lot more ways. The other thing that we can do as people who are here and who are interested in this is also to engage with such initiatives like the Arusha Initiative to continue to grow the awareness of these mechanisms, because that's one area that's also lacking, because most rights holders, most citizens, most individuals on the continent know very little about these human rights mechanisms. The states can, nominate anyone to the mechanisms because people don't seem to care about it. The more we care about it, the more we make it politically costly for states to just send anyone to these mechanisms, the more we would see more rigor and more care taken in determining who goes up there. So I hope this attempts to answer the question. And for the other question that was asked about sharing information. That's the other concern. I think it's just a good segue from my earlier response. The fact that these whole processes are shrouded in secrecy. As a lawyer trained in Nigeria, I never learned about the African Court or the African Commission in depth. I only knew about this after I started my career. So there's very little information, even for lawyers, about what these mechanisms are. Talk less of what the processes for staffing the mechanisms are. So that's our job is cut out for us, clearly, to grow awareness of these mechanisms and share the information. And that exactly is what the Arusha Initiative seeks to do, in an understanding that there is no conduit between the African Union and its organs and the African people or the individuals living in Africa, the rights holders, on so many issues, including the efficiency and functioning of the mechanism. We are trying to work together with civil society, together with academic institutions, together with national human rights institutions, and the great work that the Coalition for the African Court has been doing to grow awareness and empower the rights holders to engage in the process, to demand a space in the process. And one thing we did was to open up a platform for people to suggest qualified individuals to their states for nomination. So there actually is a space that we have to create and sustain. And I'd like to invite everyone on board. We should get law clinics involved in this. We should get citizens as part of our street law programs, our awareness building programs. We should build awareness for this. And the more we grow the awareness, it's never going to be given to us. We've got to take it. And the more we grow the awareness, the easier it will be to influence the processes positively and get the right people up there. So that's what I'll say for now.
Thank you so much, Ike. This was really a great answer. Unfortunately, and I know that there's a lot of questions that people want to ask, and really thank you so much for this lively, session and engagement. But our time is up, and now I'll give the floor to Lloyd Kovia from the Center for Human Rights, who will give us closing remarks, followed by Professor John Ampani. So Lloyd, please go ahead. Thanks.
Thank you very much, May, and thank you for the excellent moderation. Thank you so much to all the people that were instrumental, that have been instrumental in coming up with this initiative. In particular, I would like to thank ISLA. I would like to thank the African Court Coalition, RFK, and our partners, Makerere and Kabarak Universities. Thank you very much, and specifically want to thank our experts who presented and gave us some insightful, discussions. So Professor Franz Felion, Dr. Jaffe, Dr. Bosinje, Dr. Trezor, Dr. Ikechukwu. Thank you so much for really leading this discussion. It was very insightful, and I think we have learned a lot. Some of the things that we are taking away from this discussion is that the process of nomination and appointment is very opaque, and there's little public participation, particularly of civil society and academic institutions, as well as just the citizens. The issue of the formal qualifications. Yes, I think formal qualifications are there, but there are problems regarding relevant substantive experience on human rights. And the issue of political interference was also, political influence in the nomination process was also flagged, and I think it's something that also needs to be addressed. And I think the fact that there are no interview processes, both at the domestic level as well as at the regional level, and no mechanisms to ensure the suitability of candidates that are eventually appointed to this court. So these are all issues of concern, because I think at the end of the day, the objective is that we want to have an effective court which is presided over by competent and independent judicial officers. This is what we're trying to achieve. And we hope that everybody on the platform today, I was just looking at the numbers, I think almost 70 people participating. We hope that you are going to disseminate and use the information that you've learned today so that citizenry on the continent will know about what is happening and know about this particular process. And I'm informed by May that there will be a short summary discussion with a link to the recording that is going to be posted and shared so that people on the platform here will be able to assist with dissemination, and also you are able to utilize, the information that you have learned from this very insightful and high-level discussion today. So I wish you, greater success in terms of that dissemination and more awareness raising, and hopefully we can influence the nomination and appointment of suitable candidates to our, critical mechanisms for human rights protection on the continent. Thank you so much, everybody, and thank you so much to the moderator. Over to you, May.
Thank you so much, Lloyd. Thank you. Prof. Mbani?
Thank you very much. Thank you
Thank
very much, Mai. I think I'll join my brother, Lloyd, in thanking everyone, the panelists, the institutions involved, and every participant for the contribution that have been made here. And I agree with him, it has been very, very eye-opening and challenging as well. As a person that doubles up as both a human rights person and a constitutional law person, I can see the gaps from where I sit, because it appears that the constitutional governments or at the municipal level have some forms of checks and balances, and some, like our constitution in Kenya, have public participation in all these processes. But that kind of insistence wasn't made at the regional level. And I think I'm really, really glad that we are taking that up to ensure that accountability in appointments, especially to senior level of AU officials, is also taken on board. If I could just say 2-3 things as we close. One is that I think that the regional mechanisms have been strengthening over time, and they have been bold, not just the fully regional ones, but also the sub-regional ones, like, say, at the East African level, we have the East African Court of Justice. And just recently, the Supreme Court in Kenya had to make a determination on how its jurisdiction relates to the East African Court of Justice. So which means that regional bodies and sub-regional bodies actually matter. As we discussed that, some issues came up, and we had a number of conversations here in Kenya. And one of the questions was that if the judges at the local levels are going to respect decisions made at the international levels, then the judges sitting at the regional levels must, or international levels, must also have the same competence, or at least more. They should be capable of being respected. And so that means that the same effort we give in appointing Supreme Court justices or Constitutional Court justices should be the same level of rigor we also give the judges at that higher level, at the regional levels or international levels. That way, decisions that they make, and they have been making very, very serious decisions recently, can be respected, not just by the judicial bodies at the domestic levels, but also the executive and other organs of the state and the people themselves. I think that then becomes quite important, that the same structures that we had at the municipal level, for example, checks and balances, public participation, impeachment processes and such measures should already begin to resonate with the regional levels. And I'm glad that this initiative that puts us together can continue to agitate for this, so that as we fight to reform our African human rights systems or make it better, we also fight to incorporate these mechanisms of accountability at those levels. I think Lloyd also mentioned that this discussion has brought it out, as well as not just the regional levels, but also domestic levels. We need to start having those checks and balances right there as we appoint people to the regional bodies. Because many times, again, the constitutional architecture is such that we are able to control or check appointments at the domestic level, but those kind of controls, again, are not replicated when the domestic system is appointing people to the regional levels. So I'm really, really glad that something is happening here. And in that regard, I want to thank everyone else again, and remember the institutions that are involved here, particularly University of Pretoria, Kabarak University, the Arusha Initiative, and Makerere University for putting this together. And we hope that this can continue. Thank you very much, Professor Franz, for always leading us in these very important things, and also Mai for taking charge of this forum very, very ably. Thank you very much. And from Kabarak, I'm really, really fully behind all of you.
Thank you. Thank you so much, Prof. This brings us to the end of our event today. Let's continue to engage throughout the different platforms. Arusha Initiative platforms have been posted on the chat box. And yeah, let's make sure that Africa's best make it to the African court. Thank you so much.